Welcome, everybody. Thank you for joining us today. My name is Camilla. I am a third-year law student here at McGill University Faculty of Law. I have the pleasure of being in Professor Christian's tax policy seminar, and I will be the host for today's colloquium. So I'm going to start by introducing Dr. Suranjali Tandon. Dr. Tandon is an assistant professor at the largest New Delhi-based think tank, the National Institute of Public Finance and Policy. Dr. Tandon was awarded her doctorate in economics from Jawaharlal Nehru University. Her areas of research and expertise include international taxation, sustainable finance, digital taxation, and Dr. Tandon has also written extensively on corporate taxation. So as Professor Christian said, our class did have the opportunity to read her forthcoming publication titled International Investment Agreements versus Tax Policy, the Gray Area in International Law. And we are very, very excited to have the chance to ask you, Dr. Tandon, some questions at the end of the presentation and have a very interesting discussion on this topic. I encourage all attendees to ask questions directly to Dr. Tandon, but if there are any problems, of course, you can feel free to direct your questions my way. So I will give the floor to you, Dr. Tandon.
Thank you so much, Camila, and thank you, Alison, for inviting me. My apologies to whoever read this paper because it's still work in progress, so it seems like I'm rambling on in parts. But perhaps today I'll sort of structure my arguments better and take back comments and feedback, which will shape this paper better. So I'm going to just try and share my slide. So there's a motivation behind this paper. For the longest time, the Cairn and Vodafone case occupied everyone's mind. There were taxpayers extremely critical of the retroactive implementation of tax policy in India. And therefore, I began thinking, what are the limits to tax policy? What are the limits to investment agreements? And as I find, and it's in there in the title of the paper, is that it's a whole shade of gray, wherein we don't know where the line can really be drawn on tax policy and where investment agreements take over. Those who are familiar with news know that the recent decision by the arbitration tribunals seem to find that investment agreements indeed supersede tax policy, which to experts such as us is a little jarring, because the world has changed significantly since when these agreements came into existence. The needle on what qualifies as unacceptable tax avoidance has changed, but the arbitration tribunal gave its decision completely oblivious of this dimension of the transaction. So I'm going to start by looking at why this is important. So the experts who work specifically in the area of international investment agreements, and my apologies if I switch between bilateral investment treaties or international investment agreements, they mean pretty much the same. I think I've done the same in my paper. So if you look at papers by Julian Chase, etc., who are experts in the field, they do mention that there has been a worrying trend in the last couple of years, which has been that more and more tax-related disputes are now pursued under the international agreements, investment agreements. And the propensity or the preference for pursuing that line of dispute is because it's a unique platform where a taxpayer can actually take a case up directly against a state, as opposed to any other tax dispute wherein two competent authorities sort of reason out whether the tax liability is reasonable or not. That being said, there are certain standards that are enshrined within the bilateral investment treaty. We look at the fair and equitable treatment, the protection from expropriation, and I'll talk about these more in detail of why they came to be in investment agreements. But we see that these standards by themselves are rather fluid. They're not clearly defined. And as it seems, tax policy is evaluated on the basis of these benchmarks, which are not clearly defined. And so therefore, it raises the question of whether these standards are actually offering protection, which is way in excess of what tax policy seeks to do or seeks to amend in the existing structure of taxes across jurisdictions. And I've already mentioned that fair and equitable treatment and protection from expropriation are very vaguely defined. If you look at literature in the last couple of years, you see that FET is sort of evolved into sort of a vague principle, which mimics the customary international law, which was the genesis of FET. And for expropriation, now it's sort of morphed into indirect expropriation because of the changing dynamics of economies. Of course, then the related question is, what are the limits to regulation? There is obviously a palpable tension between how much to regulate, how much you can regulate, and whether this fits in within good public policy. So when experts look at a dispute under the International Investment Agreement, there is this fundamental notion that an investor has been wrong, or which is one angle of public policy. But when we look at taxes, it has a whole new dimension of public policy. So essentially, when we're talking about the tiff between, we can say the tiff between the two international laws, we are saying that it is about two interest groups and how these weigh in against each other. Of course, anyone will say now that what is good public policy, then we need to define that. For example, in this exact case, retroactive implementation of a tax policy may be seen as usurious. The government would be looked at adversely, and critics will say that no, the government does not have a right to implement a policy which is retroactive. Well, it sure can make other changes. Again, this paper speaks to this by asking when can a government go and implement a retroactive policy, and perhaps even qualifies good public policy. But the underlying issue is how did these investment agreements really come to be as they are, and whether they are actually relevant today as per the normative setting. I know that everyone in the class would have heard enough from Professor Allison, because she works extensively on BEPS, and she looks at the other dimension, which is the political economy of it. So as we're aware, the 15 action points have changed the normative setting in tax policy, which means that tax law is sort of moved ahead a century, if we want to imagine this as a tectonic shift, the pillar 1 and pillar 2. And on the other hand, international agreements are still hanging by the last couple of decades. They are still rooted very much in the principles of or thinking of when countries were not independent jurisdictions. So, so there is also a need to question what is the contextual setting of these agreements and of the legal framework. And of course, the last sort of discussion that every expert makes, and this is more so practitioners, they talk about how international agreements, investment agreements, are very useful in bringing in foreign investment. And this paper's premise or the focus is to demolish this premise. We are overtly obsessed with the importance of foreign investment. So I question that in the segment of a paper. So let's start with what is the Cairn case? What are we talking about? So let's look back at the history of the Indian tax system. What I've provided here is the section which was actually amended with retroactive effect. And if you see, it said initially that all incomes accruing or arising in India, whether directly or indirectly, through or from any business connection in India, through or from any property, through or from any asset, source of income, or through the transfer of a capital asset situated in India. Now, this was a very vague statement. It in a sense had a caveat to it that the capital asset situated in India. Now, the trick there was that how do you define transfer? What is a transfer? What is a capital asset? What is a property? And where is the source? And all of these were sort of left hanging for the courts to decide. For many, many years, the courts grappled with the issue of what exactly qualifies as a capital gain and whether it derives its source from India. The other thing is, of course, whether tax avoidance was actually acceptable or not. This is an era we're talking about when the Indian Income Tax Act did not have a guard. It did not have an offshore indirect transfer. It did not have any specific anti-abuse provision. So you're basically saying that it was a toothless legal system left to the courts to decide what really transpires or qualifies as tax avoidance. And this is something that most of you would have read in your textbooks, is a classic case of the, we call it the principle of Duke of Westminster. It's basically to say that once a business undertakes a transaction within the four corners of the law, it doesn't really qualify as abuse, and that doesn't really allow the revenue department to look through these transactions. So what you can do is just look at the form. There is no reason to question the substance. And this, this interpretation by courts actually frustrated the tax department repeatedly. So in fact, if you look at the Vodafone case, the High Court found that the revenue was right in saying that there was a capital gains arising from an offshore indirect transfer. But the Supreme Court reversed this decision and said that, and it took a policy stance to say that we should in fact accept treaty shopping in the name of more foreign investment because we're a developing country. Now that's a sad enough statement, but leaving the normative side of it, the court was making a decision which was a policy decision, and that is something that should come from the legislature. So acting on this, the government decided to make an amendment. And just a point to add that the courts were also using a separate legal entity approach, and the resident then could not be, the subsidiary could not be taken as a resident of the parent entity, and therefore the whole substance over form process could not be adopted. So there you have it. The finance minister was extremely upset that the Supreme Court had given such a leeway to Vodafone. And he admitted that, by propagating such tax planning structures, by allowing them to pursue what they were pursuing, India would actually transform itself into a tax haven, which was not acceptable at all. And therefore came the amendment, which was the insertion of explanation 4 and 5. Yeah, so these are explanation 4 and 5. Now, these are interesting because until now, the word through was assumed to mean many things. The court would say, well, of course, this doesn't mean that if you were to trade the shares which had underlying asset in India would amount to a transfer in India. And this clarification actually said, no, but it's deemed to have always been there. And it means by means of, which means that any transfer of assets which the interests in a particular entity which owns assets which are underlying in India, which are situated in India, would qualify as an offshore indirect transfer. Of course, there's another clarification, which is to say that this is share or interest. So it doesn't really stop at saying that, this is immovable property or this is a specific kind of property. It goes beyond that and says share or interest derives its value. And the discomfort that this drew was that this was applicable from 1962. So so any transaction that had occurred prior to 2012, when this was implemented, was now taxable. The capital gains were taxable on that. Until now, again, of course, this was not permissible and not possible to be interpreted. As I already said, courts could do this. Of course, then, as I said, there are different elements. You have to see where the asset is, where the transfer takes place. So the definition of transfer also changed, and so did the definition of property. So no longer was it just immovable property, it also included the right of management and control, which of course, when we move to the Cairn case, we'll see why this is important. Why right of management and control is important. It's not just immediate ownership of the asset, because when a company tries to layer its transactions, the distance from the asset and the ownership grows. And for that reason, management and control are an important addition to the law. So I'm going to now unpack the transaction, and perhaps some of you can actually express your views whether you think this really did qualify as tax avoidance or not. Happy to hear any disagreement on this. So We start with a company called Cairn Energy PLC, which existed in the United Kingdom. And Cairn Energy PLC had 26 or 27 subsidiaries, which comprised of rights of mining and of oil and gas in India. And these subsidiaries were then transferred in 2006 to a new wholly owned subsidiary created called Cairn UK Holding Company. So it's CUHL. And this was done for a value of pound 221 million. In the subsequent months, CEP also transferred a part of the debt that it held in another subsidiary called Cairn Energy Hydrocarbons and compensated CUHL issued shares in lieu of this. So as you see, CUHL is a wholly owned subsidiary and traded its shares for ownership of the 26 subsidiaries that we're looking at, of which the 26 subsidiaries owned immovable property in India. So after that transaction takes place, Cairn UK Holding Limited creates another new entity called Cairn India Holding Limited in Jersey. And what it does is that it transfers these 26 subsidiaries and the debt that it owned to CIHL, and CIHL transfers shares to CUHL again now for 251.2 million pounds. This is the third and I think the most important transaction which took place between the companies. In this third transaction, what really happens is CUHL now transfers all of these subsidiaries or the interests in CIHL, which is the ownership of CIHL to CIL. So CIL is Cairn India Limited. It is an Indian-based company and sort of undertakes activity in India. And now all these shares are transferred to CIL in the same year. So the first transaction took place in June 2006, and we're looking at this last transaction, which is in August 2006. Now, notice interesting things. First of all, there's been significant clearing. Now there's a CIHL, which is under CIL. So it's ultimately as if India's assets moved around and finally reached an Indian company. And this transaction took place at 266 billion INR. This means that it was at a significant premium. So even if we convert this, what the assessing officer found was that there was an exceptional gain of US dollar 1.36 billion. And what was this accounted for? For example, how was this executed? So for example, CUHL first bought the shares of CIL by taking a loan from CEP. It takes the loan, buys the shares in CIL, and then CIL pays it back to CUHL as consideration for CIHL. Now, what we are basically seeing is a lot of money moving through all these structures and at a premium to CIL. Now, some of this was accounted by goodwill, some of it was accounted for by share premium. The question then is, if you have share-to-share swaps, and this is accounted for by goodwill, should this actually be taxed because you're translating your profits into intangibles, which are non-taxable in this case. But surely there was a transaction which was paid for and was undertaken, and the assets that were ultimately underlying all of these ownership interests were from India. But interestingly, no tax was paid in UK, no tax was paid in Jersey, and no tax was paid in India. So it was a strange situation where layers of structures were created, in my opinion, to avoid taxes and to circumvent the law. So anyone who disagrees, if this was avoidance, if you think that I stretched my imagination. There are some comments in.
Yeah, I think so. We had a lot of trouble with this understanding the structure. So there's a lot of moving parts, and we went through that structure and actually redrew it for ourselves and tried to understand. It's always hard to visually depict transfers. So just to be clear, the underlying assets never changed hands. Is that correct? And
That's
it,
true.
yeah, and the debt was to allow the corporate entities to be moved around, and ultimately, are they sold to a third party, or do they always stay in the group? That was a little bit unclear, because I think they were sold to a third party, that they were ultimately getting rid of these assets, but through their corporate ownership.
Yeah, so Alison, this is the parts that I have described, and the one that drew contention was that this was all within the group, and the tax department sort of wanted to look at these as separate entities and treat this as a transfer without sale of the immovable property. But you're right. So ultimately, what happened was that Cairn sold its interest to Vedanta, which is another arbitration case. And so that's separate, but there was no transfer at this moment in this transaction outside the group.
Okay.
So yeah.
Yeah.
So do you think that this is tax avoidance, or would you say this is not tax avoidance? What's your view?
Well, so I think Camilla can check the pulse of others in the group, and I think my own view, which is possibly wrong. So I'm going to temper my view with one of the things that I never say, which is like, I could be wrong, right? I never say that because, well, I could be right also. My own view is that the statute that is imperfectly drafted to allow the sale of corporate shares without, when the underlying property is domestic, that's a statutory mistake and not a tax avoidance or a taxpayer. It's not that the taxpayer is wily, it's that the statute is not drafted properly. And that is foreseeable. You should be able to foresee that. Like, I think it is foreseeable to say, oh, if I make it that you have gain if you sell assets, but you have no gain if you sell stock, then clearly what are taxpayers going to do? They're never going to sell the assets. They're always going to sell stock. And so you have to draft the statute properly. So for me, I'm going to say not tax avoidance, bad drafting. But let's see if others, do you want to like just weigh in and check the group and see if others disagree? We can just see. I don't know if the students are brave enough to jump in. Yeah, Garima says she's on the fence. Are there others who want to jump in? Like, we'll just, this is not, normally we let the presentation completely unfold before we start jumping in, but what you've invited us to interrogate this, so let's do it. So Camilla, you have a few people jumping in. Yeah,
I think Scott, do you want to share what you're thinking?
Yeah, most of you don't know who I am. I'm a longtime, friend of Alison, and I'm grateful to join you. I think, and I'm no, just to say it, I'm no fan of untethered, indiscriminate tax avoidance, but I think that there's a consideration that the Indian experience in particular illustrates actually two things that the Indian experience illustrates. First of all, I think one needs to be a bit careful about, and Alison's comment alludes to this, saying that we can kind of get by displacing legal systems into the ditch. I mean, I think the question in all of these discussions is, what is the fiscal significance of the legal systems that we rely upon, both private and public legal systems, in order essentially not to have unchaotic outcomes and unchaotic behavior.
yeah.
I mean, the second observation I guess I would make is that, well, the temper of the tax times, so to speak, in the wake of the OECD's unrestrained enthusiasm for universal reconstruction, but I don't have a view. The Canadian statute, for example, does exactly what Alison says. If the underlying value of the property is something that we care about from a social and an economic point of view, namely manifestations of real and immovable property, including natural resource property. And we only excuse that extended reach of jurisdiction, which is a public law issue in and of itself, in the case of the Canada-United States Treaty, where where we don't purport to tax dispositions of shares of U.S. companies that happen to be valuable because they own Canadian real property. And the last thing I guess I would say, and I think this always is, the facts always matter. Like the case that's up on the slide now in some ways is a derivative of the experience to the Indian courts as I read it, of the Vodafone case, which has caused, all kinds of issues about what the proper constitutional and then public law reach is of a domestic statute. But if one actually takes the trouble to look at the actual transaction documents in the Vodafone case, what you find, and this may be a consequence of just how property is transferred in India, and in particular intellectual property and rights to it don't go into the public domain. The actual transaction documents, which were consummated by transfers of shares at the upper level, had underlying transfers, legal transfers in India between Indian companies of particular property rights. And so the case is somewhat more difficult, I think, than it appears to be, because the adjudicators were having to face the fact that there actually were transfers of Indian property by Indian taxpayers. And now whether they were simply legal transfers to prevent property from going into the public domain, or whether they were substantive transfers of valuable property for consideration, is sometimes a hard question. But I think, again, the facts matter. So I'll just stop there. I don't want to get in the way of your presentation, which I'm enjoying. Thank you.
Thank you so much. I think that's a really well thought out comment. I agree with Alison that it's poor legal drafting, and if I may for a moment just justify the retroactive legislation, it was to fix these infirmities, and I'm going to take that point and sort of move ahead to talk about international investment agreements, and happy to take these agreements further into the conversation. So next slide, please, Alison. Yeah, so I think there are a couple of questions that remain for tax policy, which is, where is the source? I think that's also true from the conversation we've just had, that there is sometimes a transaction between one resident and one non-resident, or between residents or just between non-residents, entirely non-resident entities. And so then when do we say the source really lies in India? And this is a sort of conversation which is also happening for capital gains in other spaces. What is impermissible tax avoidance? Again, reliance is placed on general anti-avoidance rules. For example, now India in 2017 since 2017 has in place the GAR, which of course defines certain circumstances, but it's hardly triggered. And that goes to show how difficult perhaps it is to even define tax avoidance within the tax department. The last one, of course, is to say what is offshore indirect transfer, whether we should tax it. And there's been a bit of divergence in how the OECD looks at this and how the UN model looks at this. So for example, the OECD stops at saying interests in immovable property, whereas the UN model goes a step further to say it could be just the transfer of interests. And that is Article 13.5, which doesn't exist in the OECD Model Convention. Today, there are 336 treaties which contain Article 13.4, and it is said that it is less likely. So Platform for Collaboration and Taxation, PCT, says that it's less likely to be negotiated between developed and developing countries, which means that the problem of taxing capital gains is not going away anytime soon. And such structures are going to perpetuate in the future. So tax law will have to adapt independently or unilaterally to address such transfers. So I'm going to move forward and now talk about what is the BIT challenge. So there are fundamental principles within the BIT, which are enshrined in the articles that are available or proposed in the BIT. One is the Article 4, which is fair and equitable treatment. Now, this was essentially to make sure that investors or foreign investors are granted similar treatment as domestic investors would, or any other investor from any other jurisdiction would, which is to ensure that there's a level playing field and there is a history to why it evolved the way it did. The second one, which is important and was invoked in this particular case, was the limits to expropriation. So one of the most important articles within BITs or IIAs is protection from expropriation, and this really came to form after countries began to nationalize in the 80s, and there was fear of takeover of assets by foreign investors, or by these governments, and foreign investors fear that they would lose their investment. So expropriation, though looked at negatively, as was nationalization, and there are limits to that. If it is for public purpose and for internal regulation, a just compensation is to be paid to the foreign investor. And lastly, which is another interesting and contentious issues, especially from the point of view of countries like India, is the availability of arbitration as an option to resolve these disputes. So moving from here, we're going to look at what are these legal principles and what do they really mean for countries. So the first would be the origin and purpose of IIAs. So anyone who looks at the international investment agreements as an evolved form of thinking should go back and look at the history. It really, the genesis of these agreements is in the FCNs, which was signed by the United States, and it was a completely different era in economic history. This was a time when US was expanding its trade, and these treaties were really signed for the US to gain access to markets. And if you look at this, the FCNs, there were few principles that underlie these agreements, which is protection of property, national treatment, and no arbitrary action. Not very different from the BITs we have today. But something changed along the line from the 18th century, from being a defensive reaction, from being a treaty which was supposed to lead to greater economic relations, it became a defensive reaction to past expropriations. Somehow US shifted its position. It valued more prompt and adequate and effective compensation rather than just the protection of investment. And this leads us to ask the question that if countries after the 1990s began to liberalize their capital accounts, which means essentially the regulation of inflow and outflow on inflow and outflow of capital went down, what did really the investment agreements seek to serve? Because expropriation and nationalization are extremely problematic when such capital controls exist. So, so the context for BITs and how they were designed completely changed after the 1990s, but the content did not. Experts will tell you that some of these provisions look exactly the same as they did way back in time. The other important element is the asymmetry in expectations. So if you look at any investment agreement, there is one part of it which says to protect, and the other part says to promote investment. Now, if you look at the protect part of it, that is exactly what developed countries seek to achieve. But in terms of promoting investment is what the developing countries seek to achieve. So the expectations of capital exporting and capital importing countries, and I think all of us are aware of this, it also plays out into tax treaties. But in investment agreement as well, not just in expectations, also in implementation. There is no reciprocity. So the developed countries are able to assert their rights more strongly because they are the exporters of capital. And of course, I also seek to ask why IIAs are now important. Because if you look at the experience after 1995 to 2015, there have been about 39 episodes of 46 episodes of capital flight in 39 developing countries. And they did not all systematically ratchet up their capital controls, which basically means that they suffer from external shocks and vulnerability, but have no protection. But on the other hand, the developed countries have a free hand on deciding what amounts to expropriation, what amounts to fair and equitable treatment. So it leads me to the question of why shouldn't this normative thinking on international agreements evolve? If we look at literature again, tribunals have been reluctant. Now, of course, the legitimacy of these international arbitration tribunals is itself a question of how these experts are chosen. But leaving the politics aside, the question is, why have tribunals not accepted the change in economic reality when IIAs govern economic relations? So I now move to the next one, which is the FET standard. So this has been a bit of a problem. It's been a thorny issue for most countries, because if you look at disputes, most of them invoke the FET. And why do they do that? So let's go back to the 1964. Prior to 1964, there wasn't any sort of framework to rely on to resolve such international disputes. Everyone relied on customary international law, and legal experts will tell you that customary international law is really not law, it's just a set of norms. So what you got was dispute hanging on, which is like, if you take the case of Anglo-Iranian Oil Company. Now, what was essentially being done here, what really happened here is that Iran offered an incentive on mining oil and suddenly withdrew it. And the UK was unhappy about it. And therefore, there was this new need to define relationships through a formal framework. And that's how your international investment agreements began to take traction. Now, what has happened is, strangely, the concept of FET is quite akin to customary international law. It has evolved or developed through, the practices or the interpretation of the arbitration tribunal, which is how common law evolves. But unfortunately, these are non-binding precedents. So basically, a tribunal can take a decision in one way in a particular case, and that may not bind the next tribunal on the same. And so therefore, FET becomes a fluid concept. So what is fair, what is equitable is to everyone's guess. The other important component is that if you look at FET, if you try and define it, there are certain fundamental principles that people look at. So of course, it shouldn't be, the policy should not be usurious, should not be coercive. But what is interesting is there is this stress on legitimate expectations, and so much so in retroactivity. So what are legitimate expectations? Basically it speaks to or panders to the investor's need for certainty. And what plays out really is that there is asymmetry in the application of FET. So if you look at legitimate expectations, it is always interpreted in terms of what the state should do to avoid confrontation with the investor. But it speaks little or never at all to what the investor should do to ensure that there is certainty and stability in their reaction or response to the legal framework. And what you've seen is the whittling down of legitimate expectations because of this asymmetric application of the fair and equitable treatment. And the defects that exist so far, as I said already, that to the FET are only cured by tribunals, and tribunals are ad hoc. So we are basically saying that there are few experts who decide a case-by-case basis, and these results don't always hold. Interestingly, and Alison might find this interesting, there was an attempt to sign a multilateral agreement on investments way back in the 90s, and the OECD was leading charge on this as well. And what they wanted to do is to define these principles. And interestingly, civil society, there were practitioners, etc., who fought back, saying that these standards actually give more power to multinational corporations than they actually provide a level playing field or any kind of investment. So, in a sense, the multilateral agreement fell flat on its face. It never came to fruition. It was abandoned because the expectations of countries were different, and the results were not exactly acceptable to all. And it's quite telling of where we are today in terms of even tax policy. So the summary of this slide is that FET itself is a vague, ill-defined concept, and it holds up the state to a different standard than it holds the investor. Yes, so the other one is expropriation. And this again goes back to US's dealings with Latin America and other countries. And the fear was that any property that was acquired in a state would be either nationalized or taken over. And so there was an explicit demand to sort of protect against expropriation and with speedy compensation and just compensation. Now, the interesting thing, the point that I've already made before is that capital account liberalization changed many things. Liberalization in the capital account also came with liberalization of the economies. There was more open trade. And so therefore it raises the question of why this standard is required at all. And why this is even more important is that now expropriation has donned a new hat. It's not just direct, it's indirect expropriation, which again constrains policy changes. So for example, if you even take the case of this retroactive legislation, it was deemed to be expropriation. Now, leaving aside the details of it, how far can an investment agreement go to tell policy or inform policy on what it can do is questionable. This basically means that domestic policy is in all circumstances, even if in public interest, is superseded by an interest which is dated. So this is the other problem area and ill-defined area for international agreements. This is of concern to all of us who even work in taxes, is the dispute resolution process. Now, countries like India have taken explicit position that they are not amenable to arbitration. And this is something, if you look at the 500 odd page arbitration award for Cairn, they repeat this and they say that even while signing the MLI, there was an article on mandatory binding arbitration, which this explicitly ruled out. They do not wish to introduce mandatory binding arbitration at all in the future. Now, of course, that arbitration looks slightly different because it's a baseball method. There are two competent authorities who thrash out the matter and one solution wins. This is slightly more problematic because it says that the state can be taken to a tribunal directly by the taxpayer. And the solution or the outcome that will come out will be completely different, could be completely different from what is being suggested in either case. So it becomes exceptionally problematic for countries like India. This is also problematic because the Indian law itself does not permit for arbitration in tax matters. It's not a commercial matter. India has not even signed the ICSID. It's signed the New York Convention. And I think the most important part, which also when you read the arbitration award, is that they do not have the expertise. So there is one tiny paragraph in the award where the panel actually admits to its lack of competence in the matter, but goes on to say whether this award should be granted, which is a little unfair because it's stepping on the toes of tax policy at the cost of protecting the investment in the jurisdiction. So it's a big question mark of whether this process should actually be accepted. And in fact, if anyone has followed it through, it became extremely embarrassing because this was then enforced by the investors abroad. They threatened to seize assets of the Indian government. And so India cannot, the award cannot be enforced in India, but it can be enforced in any country which is a signatory to the New York Convention. And what India has the option to do is to challenge this by saying the due process was not followed, or the arbitration tribunal cannot rule in this matter. And that continued until today. Now we've sort of reached an agreement to settle this matter. But the question still remains, right? Whether such a process should be available at all to the taxpayer. Moving beyond the principles, I think there are major definitional issues as well. So if you look at UK BITs, it says every kind of asset, including the concessions provided by the government, which means a wide scope of assets can fall under the purview of an IIA. What is hilarious is the US definition. which is circular. It says every asset that an investor controls, directly or indirectly, and that has characteristics of an investment. So you're basically defining an investment as akin to an investment, which means that you can expand the scope of what is covered under it and sue for that. So by this logic, basically fund structures which we've seen in the Cairn case, which are used to circumvent the law, would also qualify for this protection, under investment agreements. Although interestingly, if you look at the Canada and EU comprehensive economic trade agreement, they have made a specific exclusion for shell companies. So there are certain treaties which make exception for such forms which are used to exploit the law, but they're not quite widely available. This is another issue which often comes up in the conversation, and I know that Alison thinks about this more deeply than I do, but I'm just going to make a couple of comments here to say that tax sovereignty itself is not a very well-defined concept. I mean, if you read Rickson's work, it's fantastic. It says that it's a fluid concept as well. There are no absolute quality, and it of course changes over time. So Alison, I think you made a comment in a session saying that if you sign up to agreements, in international agreements, then in some way your sovereignty is compromised already. So so what are we talking about sovereignty when we've given up some of the rights under the international agreements? But I think there is another metric for evaluating sovereignty, especially in the context of international investment agreements. One is to test whether any right which is provided is in violation of fundamental rights. Is the right which is provided under the international agreement superior to what is guaranteed by the Constitution to the citizens? And whether this is in complete line with the thinking, at least when we're talking about tax matters, is it in line with tax law? Now, each of these we can sort of deal with, and I'll speak about these. First is fundamental rights, right? Now, I want to look at it in a different way. What are fundamental rights under the Indian Constitution? The most interesting one is the property right, the right to property, which is no longer a fundamental right. It's just there. It's protected, but it's not sacrosanct. But now, what does the investment agreement do? The investment agreement offers compensation, offers protection, which is much higher than the constitutional right guaranteed by India. So the international investor has more or stronger investment rights over property than a domestic investor does. In terms of, if you look at the thinking again, going back to BEPS, the tax law has changed significantly. If you go from 2016 up to 2020, the tax law has evolved significantly to rule out certain practices, to close loopholes. And what has happened, on the other hand, on the investment law, and this could be the fault of fragmented thinking within India, where the tax law is drafted by Ministry of Finance, but the investment agreements are really under the Ministry of Commerce, and both have split thinking on what takes precedence. And this fragmentation of thinking has poured into fragmentation of law, which I think even the UN acknowledges as having happened because of greater specialization. So if such fragmentation does happen, it could override sovereignty. Okay, the next issue is that people look at the retroactive legislation as an aberration in India. They say that this is absolutely unacceptable. India is the only country to have done this. Is it true? Well, no. I think the change in tax narrative, wherein the tax department was said to have been carrying out activities akin to terrorism, are unfair, because it ignores that the amendment was in public interest. Now, if you look at country experiences, and there is interesting literature on what countries have done in the past, you look at some of the major countries, including UK, which brought the arbitration against India. In fact, levied a similar tax. In fact, if you look at UK, in 2008, they brought about that change with the same language, saying that the tax would be applicable as it had always existed. And it was to curb structuring malpractices through Isle of Man and Jersey, which is exactly what the situation in Cairn case, right? So, and the UK constitution does not prohibit this. Similarly, if you look at Canada, it's perfectly possible if the law is interpreted in an unexpected manner. In US, other than for criminal law, there is no explicit constraint on economic legislation. For Germany, again, it is possible to do it in the interest of the taxpayer. In Italy, it can be done in exceptional circumstances like joining, let's say, the EU, or in case of avoidance. Sweden in the name of economic justice, and Netherlands, interestingly, the Supreme Court never really ruled that the retroactive legislation was in violation of the European Human Rights Convention. So what we're basically saying is that it's possible, and there are no limits, and there are countries who actually pursue a retroactive legislation in their own public interest. The public interest, of course, subject to interpretation. So going back to the issue of constitutional challenge, in India, it's perfectly possible for the parliament to legislate retroactively on tax matters. Interestingly, none of the taxpayers have challenged the constitutionality of the retroactive legislation, which to my mind is curious, because at least they should have raised the question. And they did do that. They did bring up the issue in one of the matters, but the tribunal, the tax tribunal, ruled that this was not their jurisdiction. So I don't know if they pursued it any further. The other thing is, taxpayers tend to stress a lot on legal certainty. But I think as an economist, I think there is a need to define what is the cost of this certainty. So can we afford certainty to some taxpayers at the general loss of all other taxpayers? So if you look at just this instance, there were 17 taxpayers that were caught in the web of retroactive legislation, 17. And only 2 of them accounted for the tax that they had avoided, accounted for the double of the securities transaction tax collected in India. This is a levy. The securities transaction tax, to those who don't know, is a levy on transactions on the stock exchange for listed securities. And it's a fraction, but then again, it's quite significant. And even if you look at the distribution of taxpayers and their income reported, the bottom 7.4% report income the equivalent of tax by these 2 taxpayers, which is Cairn and Vodafone, which really goes back to asking what is economic justice and whether this legislation actually stood to reason, looking at the inequality in the application of law. And of course, we talk about good faith. India is not a signatory to VCLT, but good faith is another norm. And again, I'd like to question if good faith only unilaterally applies to a state. What happens to MNCs, which hide behind international law as only passive recipients of this law, but never really held up to the standards? So should the standard of good faith actually be applied to MNCs who are bringing the case against the state? So I'm going to proceed with the last part with a great deal of skepticism. So this is a teaspoonful of salt. For those who support that investment agreements are absolutely fantastic for investment. So in the next slide, I show that there has been a trend of at least a burst of treaties being signed between 1990 to 2007. Just speaks to the earlier point of we signed these agreements, we got more disputes. And of course, as the result of these agreements were signed, but what did we get as investment from this? And whether this was really warranted. So if you look at distribution of investment, the numbers are, there is a very interesting point. So if you look at this map, it basically shows that for most of the world, the share of FDI stock in their GDP has been around 6.15% or less for most of them. And what we're saying is that the protection to be offered, which is, all kinds of things like expropriation, protection against expropriation, and direct action against state, is for this 6.15%. So what is the link? What is the impact that this investment ought to have on growth, on employment? It's a big question mark, but in its name, we offer protection, or which is, I think, disproportionately high. In fact, if you look at the UNCTAD numbers, there are 26 countries in the world which account for 86.7% of FDI stock. But if you looked at the previous slide, there are about more than 3,000 or 2,000. There you go. You have about more than 3,000 treaties. So if you look at this, what you're seeing is that there are countries who are signing up to agreements for nothing. Because if the FDI stocks are concentrated and the investment agreements are widespread, I'm trying to knit them together to try and understand what the benefit is and why are countries actually signing up to this. If you look at the next slide, which is an interesting graph, basically it looks at net foreign direct investments and net portfolio investment inflows into India. Now, most of the investors upset about the Cairn and Vodafone case will tell you, well, FDI did not like what happened and all these investors moved out, or they didn't bring in money. But if you look at the graph, leaving aside portfolio flows, which are generally volatile in nature, they really picked up in volume, in value, and even though they're volatile, they're higher than the previous decade before 2007-8. And 2012-13, when the retroactive amendment is introduced, that's exactly the point of inflection in FDI. It picks up, it doesn't really slow down. Which raises the question of why at all are we worried about the disputes? Is it that the large taxpayer is setting the narrative for India? And whether that needs to be reformed rather than saying that the tax law itself should have been reformed. So this is a lot of econometrics. I'm not going to go into the detail, but this is asking the question that if everything else remaining the same, if growth globally picked up, should India have received more FDI, and was it impeded by the adverse decisions? Now, if you look at the period from 2012 to 2020, there's been a bit of fluctuation, but the forecasted value based on global growth, Indian growth, it's been in line with what we've actually received, which again raises the question of are we frightened more than we should be by the scourge of foreign investors? Again, going back to saying that should we re-examine what our investment agreements really look like? So I'm going to end this with a few thoughts. I think despite what I've said about the international agreements, investment agreements, what I've said about tax policy, the best way to resolve this conflict is to build in exclusions and say that tax is out of the ambit of investment agreements. The UN says that there are different approaches. One you could do is that you could say that the investor, which is a mailbox company, is completely out. So if you can say that there is no substance in the transaction, it is automatically not covered by the investment agreement. And then again, it could be that you make an exclusion for any transaction which is outside the scope or the control of the country's law and regulation. What is interesting to be done in India is that there's been an explicit exclusion for bilateral investment treaties for tax-related measures. It completely rules them out. At the moment, India hasn't had much success negotiating this with many countries. As you know, it would not be very successful. There are a few small countries that have signed up. Maybe I think Nepal has signed up to the new model convention. All the other treaties are suspended. The old treaties are suspended. So we'll have to see in the future if India actually signs these investment agreements and if these exclusions really pan out. What remains in my mind is that the arbitration tribunal drew a very, very thin line between investment disputes, tax disputes, and concocted a new term called tax-related investment disputes. Now, if this continues, does that mean it's opened a Pandora's box that more disputes will now come under the head of tax-related investment disputes, and building in an explicit exclusion, it doesn't really solve the problem. So we're going to enter a new phase of disputes. So thank you so much for listening to me, and that's my presentation.